Hello everyone, and welcome to today's webinar. We have a great session lined up for you today.
Good evening, everyone. Thank you all for joining us today. My name is Ananya Kumar, and I am here today with my two colleague partners from JSA, Anand Lakra and Tirthankar Datta. As you can all see from the slide in front of you right now, Anand, Tirthankar, and I have been tasked with speaking to you this evening on the legal and regulatory considerations surrounding listed company acquisitions. The topic, if taken as a whole, though, is extremely broad, and time, unfortunately, is somewhat limited. What the three of us have decided to do, therefore, is to focus on the Indian takeover regulations and the associated legal and regulatory considerations arising from it. Before I hand over to my colleagues, let me just give you a brief introduction of the firm and of ourselves. JSA is a 32-year-old firm with presence across 7 jurisdictions in India. We are presently over 400 lawyers and over 100 partners. We're a full-service law firm, and our work is broadly divided into 3 practice areas: corporate, banking and finance, and dispute resolution. And you have representation today before you from each of these practice areas. Anand is a partner in JSA's Mumbai office. His practice focuses on private and public mergers and acquisitions, private equity and venture capital investments, capital market transactions, and he focuses specifically on security law matters, publicly traded companies, delisting offers, and takeovers. Tirthankar is also based out of the firm's Mumbai office and specializes in banking and finance, financial services, mergers and acquisitions, and cross-border investments. And he has extensive experience in structured debt transactions, including all manner of finance-related transactions. I myself am a partner in the dispute resolution practice based out of the firm's Delhi office. And my focus is corporate commercial litigation and arbitration. Anand and Tirthankar will be taking the lead in today's discussion. And Anand will first be taking you through the salient features of the takeover regulations, which are the principal or the key regulations involved in listed M&A. He'll be covering the basic concepts under the regulations, and will also be dealing with recent amendments in relation to both the takeover regulations and the listing regulations, both of which have an impact on listed M&A. Thereafter, Tirthankar will be dealing with offshore and onshore acquisition financing, juxtaposing it with the limitations placed by the maze of Indian laws and foreign exchange control regulations, as well as the implication of creation and enforcement of security under the takeover regulations. Once you've heard from both Anand and Tirthankar, I will try and take you through the primary types of disputes that can be seen in listed company acquisitions, their nature, and the fora for dispute resolution. Together, what Anand, Tirthankar, and I hope to do is to be able to provide you with a multi-perspective understanding of today's topic. With that, let me hand over to Anand, who will be dealing with the first part of today's presentation.
Hi, good evening, everyone. Thank you, Ananya. So as Ananya mentioned, I'll be covering takeover regulations, which is one of the key set of rules which get triggered or are involved when one is doing a listed merger and acquisition deal. And given the time constraints, I think it'll be fit if I cover some basic concepts, take you through a broad overview of what the takeover regulations entail, what is the role of a regulator, what are the duties cast on a potential acquirer, etc. Now, of course, the most basic question is, what is an open offer and why is an open offer mandated by the Indian takeover regulations? To simply put, an open offer is an offering. It's an offer made by an acquirer in certain situations, and we'll be covering those later, that the acquirer has to acquire a minimum percentage of shares from the public shareholders of a publicly traded company in India, or which is listed on the stock exchanges in India. If a potential acquirer is acquiring a certain percentage of shares, whether from the open market or from the existing shareholders, once certain thresholds are crossed, there is an obligation on the acquirer to make this open offer to the public shareholders. And in the Indian context, this is important to understand why I say the public shareholders, because in India, Broadly speaking, the shareholders are divided into two categories. One are called the promoter shareholders, which effectively, in other words, are the controlling shareholders, and everything else is classified as a public shareholder. So it's important to note that the open offer is made to the public shareholders only. And why is an open offer made? Again, when a public shareholder invests his money and acquires a share of a listed company, it does so with certain assumptions that it's being controlled by a reputable set of controlling shareholders, and therefore, he sees a potential sort of investment in that particular company. Tomorrow, if those controlling shareholders were to change and someone new comes in and takes over, the law requires the new person, the new controlling shareholder, to give an exit to the public shareholders. And therefore, the law requires the new acquirer to make this open offer and give a exit. It's up to the public shareholder then to either partake in the open offer his shares, or simply carry on with the new management, with the new controlling shareholder. Essentially, that is what that's the underlying theme, the rationale why the law requires an open offer and what is an open offer. Moving on to a very critical concept, which is acquirer and person acting in concern. Acquirer, as the name suggests, obviously could be anyone, could be an individual, could be a company, which has an intent to either acquire shares of a publicly listed company in India or acquire control with or without shares. In either of these cases, an open offer could get triggered, and we'll cover the triggers as well. The person whose intent is established is called the acquirer. And a person acting in concert is someone who is effectively supporting the acquirer in making this acquisition. Now, that support could come in many ways and in many forms. For example, it could be a financial support. It could be management support. If someone is funding the open offer, but actually not acquiring the shares, that person would be a person acting in concert. So, to put simply, it's someone who has helped the acquirer make the open offer. There is a collaboration between these entities, these persons, and therefore the law would treat them equally. So under the takeover regulations, whatever the acquirer is responsible for, the person who's acting in concert is also equally responsible. They have a joint and several liabilities. So in terms of the law and in the eyes of the law, they're treated as one entity, one unit. Now, the obvious question is, when is an open offer required to be made? What are the triggers for it? In what situations an open offer is not required to be made? Obviously, not all acquisitions of Indian listed companies require an open offer. Broadly put, there are two broad categories when an open offer is triggered. First is on an acquisition of voting rights, and the second is on an acquisition of control. Now, control may be through an agreement with or without actually getting the shares. Even in those cases, an open offer would get triggered. So that's a very clear-cut control sort of trigger. The second is a voting threshold-based trigger. That's the category, which is further divided into two categories. One is if your starting position is 0%. Let's say an acquirer, potential acquirer, does not hold any shares in the company and is at 0%, and acquires 25% or more of the voting rights or the voting capital of the listed company. Doesn't matter how it's acquiring it, whether it's a secondary acquisition or whether it's infusing funds into the company, irrespective of that. Once it crosses the 25% mark, that's a trigger for an open offer. The second trigger is assuming the starting case is the acquirer is already holding more than 25%. In that scenario, once the acquirer buys more than 5% in any one financial year, that becomes another trigger for an open offer, which is in the Indian context is referred to as creeping acquisition. How you're basically creeping up your shareholding. This is the voting test trigger, and like I earlier mentioned, there's a control test trigger as well. So typically, if an acquirer does not want to make an open offer, it would ensure, and let's say its starting shareholding is 0%, it could buy 20% and does not acquire any controlling rights, does not get a right to control the management or the board, in that scenario, there would be no open offer. So there are only specific certain situations when you're looking at an open offer. Now, what is offer price? Obviously, there is an offer which the acquirer has made to the public shareholders of a listed company. It has to acquire those shares. At what price is the question? Now, this is under the Indian takeover regulations regime. It's not a free pricing offer. Offer price is regulated. There is a minimum price which an acquirer has to offer. There are many parameters for discovering what that minimum price is, but to simplify, it's a combination of two primary factors. One is the historical traded market average price of the relevant company's shares, and one is the price that the acquirer has paid to either buy out the existing controlling shareholders, or the price the acquirer has paid when it's infusing funds into the company. That price, whichever is higher, becomes the bare floor price which the acquirer has to offer to the public shareholders. Now, there is a sort of a nuance to this, given that one of the parameters is a historical market price. That obviously the law assumes that the stock is being traded frequently. In a case where there is less trading activity in a particular scrip, then the acquirer has to conduct a valuation exercise, and whatever number that valuation exercise throws up becomes your offer price. So that's the price an acquirer has to offer to the shareholders as part of the open offer. What's the offer size? The offer size is 26%. Again, this 26% is of the entire share capital of the listed company. And the science behind 26% goes back to the first trigger, which I had earlier mentioned, is the fact that the first trigger on a voting threshold occurs at 25%. So let's say an acquirer agrees to acquire 25% from the existing controlling shareholders. The offer size is going to be 26%, and assuming the offer is subscribed in full, it'll take the shareholding of the potential acquirer to 51%, 25% from the existing shareholders, plus 26% is the offer size. So effectively, when you go into an open offer, you need to at least, in fact, SEBI mandates that the acquirer has to show that he has the funds to acquire at least 26% of the total voting share capital of the listed company. Now, I'll spend a couple of minutes on the offer process, because this, unlike there are certain offers in the Indian market which are not heavily regulated. Takeover open offer is one which is regulated, which is scrutinized by the securities regulator SEBI in India. Now, in terms of the open offer process, once an open offer is triggered, basis whether a control trigger or an acquirer has acquired a minimum voting threshold, the acquirer has to issue certain offer documents. The first document has to be issued, which we routinely call a public announcement, is the day the acquirer establishes his or her intention to acquire the requisite number of shares or has agreed to acquire control. On this very same day, the first announcement has to be made to the market at large. The deal becomes public, that there is a potential acquirer. He has stated his intention to take over this company, and therefore officially the open offer process starts. Once that announcement is made, there are a couple of other offer documents which the acquirer is required to issue. One of the key documents is the letter of offer, which is sent to the shareholders. The letter of offer is only sent to the shareholders once SEBI sort of gives its soft approval or gives a go ahead, without which an open offer cannot continue. SEBI, being the securities regulator, will scrutinize the letter of offer to ensure that all the compliances which are required under the takeover regulations, the calculation of the offer price is in line with the takeover regulations. There are adequate disclosures about the background of the acquirer, his intention, what he intends to do once he takes control over the target company, so on and so forth. So all of these disclosures, the offer price, the offer size, so on and so forth, gets scrutinized by SEBI. Once the acquirer receives SEBI's blessing, then the offer can proceed subsequently. Now, going into certain exemptions, there are certain transactions which are exempt from making an open offer, even if, let's say, one were to cross the thresholds which are required for triggering an open offer. For example, like I earlier mentioned, an open offer could get triggered upon acquisition of 25% of the voting share capital. Now, assuming, let's say, there is an acquisition between immediate relatives, a father and a son, a mother and a daughter, father and a daughter, so on and so forth. If there are intra-relative transfers, the takeover regulations would grant them an exemption status. There are certain disclosures and there are certain conditions which one needs to fulfill. However, these kind of acquisitions are exempt and there is no open offer. Similarly, if there are certain shareholders who have been identified and disclosed to the public at large as controlling shareholders, as promoters, even though they are distinct groups or they're not even related or part of the same family, as long as they're disclosed to the public at large as promoters, any transfer of shares between them, subject to again certain conditions being met, would be exempt from making an open offer. Similarly, if there is an M&A activity, let's say there is a scheme of merger involving a listed company and any unlisted company, even in that scenario, SEBI would not expect the ultimate acquirer in a scheme to make an open offer, given schemes of arrangements in India are regulated. There is a company law tribunal which sort of overlooks that process. In these particular examples, you'll get certain specific exemptions. And to ensure that the acquisitions are exempt, there are certain disclosures, there are certain conditions which around pricing which need to be met. As long as those conditions are met, exemptions would be given. Moving on to some recent amendments in the takeover regulations which impact listed M&A activity. Now, recently, an acquirer has been allowed to acquire a listed company, and if it wants to delist and take it off the stock exchange platform and convert it into a private company or a take private offer, the law has now permitted an acquirer to make a combined offer. Effectively, let's say an acquirer comes into a position over a listed company and feels that it will be better if the company becomes a private company. Before this amendment, the acquirer had to first make an open offer, finish the acquisition under the open offer, and then wait for some time, and then subsequently make another delisting offer or a take private offer to take the company private. The recent amendment now has allowed the acquirer to combine these two offers. So effectively, the acquirer would start with an open offer and then move into the delisting offer phase. If the delisting offer is successful, the open offer stands withdrawn and the delisting carries on and the company is turned into a private company. So that was the whole idea, to sort of introduce this instead of having to make two separate offers with a time gap. An acquirer now possibly can, in one shot, make an open offer, take the company private, and be done with it. Now, given this is a dispensation given to potential acquirers, there are certain bells and whistles which come around making a combined offer of such nature. The first obvious question is who can make it? Unlike a classic plain vanilla open offer, a combined offer, an open offer plus a delisting offer, cannot be made by every acquirer. Such acquirer cannot be an existing controlling shareholder, has to be someone new. Such acquirer, for example, cannot acquire joint control with an existing promoter. Effectively, this is meant for entities which are coming in, which have no shareholding in the company currently and completely want to take over and take the company private. If it's a joint venture situation, for example, where you partner up with an existing shareholder and you want to jointly control the company going forward with your partner shareholder, such offer is not open for those acquirers. The second critical point is regarding the announcement. Given that this is not a classic simple takeover offer, it's a takeover offer combined with a delisting offer, it's imperative that the acquirer announces the intention to take the company private, to delist the company upfront on the day of the public announcement, which, like I had earlier mentioned, has to be made the first day the acquirer establishes his or her intent to make a triggering acquisition over a listed company. That public announcement should categorically state the intention of the acquirer, that it's not a simple takeover offer, it's an open offer, plus it's a delisting offer. If this intent is not disclosed, the law will disallow the acquirer to do a delisting offer subsequently. And therefore, in other words, the acquirer has to be very clear whether he's making a simple, straight open offer or whether in his mind this is a combined offer. In terms of pricing, now, unlike open offers, where open offer pricing is regulated, there's a minimum offer price which the law regulates, which has to be offered to the shareholders. In a combined offer, while the open offer price, will use the same formula which is applicable in a classic open offer. For a delisting offer, it's left to the acquirer. Whatever premium the acquirer feels is good enough to get the tender level from the public shareholders, the acquirer is free to offer that. Now, this is a slight deviation typically from the delisting offers, where in a classic delisting offer, it's the public shareholders bidding which determines offer price. But in a combined offer, it's important to note that the offer price is determined by the acquirer, offered by the acquirer. The only rule concerning this price is it has to be more than the book value of the listed company. As long as you hit that threshold, it's up to the acquirer to offer whatever it feels commercially reasonable, whatever will get him the relevant tender level. And the relevant tender level, again, it's important for a delisting is 90%. You must get your shareholding must reach 90%, keeping in mind your existing shareholding plus whatever you're expecting from the public shareholders. If it does not hit the 90% mark, the delisting offer fails. And therefore, the pricing plays a very important part. If there is not enough premium, you may not hit the 90% mark, and the delisting offer will fail. Now, what happens in a combined offer? You started the open offer, you made your intent very clear that this is just not an open offer, it's a delisting offer plus an open offer. You start with the delisting while the offer is going on, you don't get the requisite number of shares, and the delisting offer fails. In that scenario, you go back to the open offer, you finish the open offer, you give the open offer price to the public shareholders who've tendered, and the offer closes. If after the offer closes, acquirer still feels it wants to have another go at making another take private offer, it has been given a period of 12 months to make another delisting attempt to try and take the company private again. Now, there are certain recent amendments in the listing regulations as well, which impact the listed M&A activity in India. And these have been very recently introduced, and they're very, very critical. There is a concept which SEBI has introduced of special rights. Unfortunately, the law and the regulations do not define what these special rights are. But effectively, if any shareholder is being given special rights in a listed company in India, needs the blessing of the shareholders. Now, while the law does not define what these special rights are, there are discussions, there are papers which have been issued by SEBI before this law was formally introduced, which throws some light into what SEBI perceives to be special rights. As one would know, in every acquisition, an acquirer would want certain shareholder, certain management-related rights. For example, it would want a right to have his board member be part of quorum. It would want certain share transfer restrictions, the classic right of first offer clauses. It would want tag-along clauses. It would want certain exit rights if it's especially a financial investor. All these rights, SEBI would consider special rights. And if these rights are being granted to any shareholder, whether or not that shareholder is a promoter, whether or not that shareholder is making an open offer or not. If a shareholder is being granted these rights, you need the shareholders' approval of the listed company. There are, of course, certain exemptions. Typically in financing transactions, if certain nominees, certain lenders are given, for example, lenders always have a right to nominate a member on the board. Now, those lenders, those financial institutions, they have been exempted from this shareholder approval requirement. The second amendment in the listing regulations deals with a sale of undertaking of a listed company. Now, this too requires shareholders' approval, and this was always the case even under Indian company law. However, what SEBI has brought in is the concept of majority of minority. Effectively, if it's a listed company and it's selling its undertaking to any third party, while it continues to require a special resolution, but the added obligation now is it also needs to meet another test, which is the public shareholder. There should be a majority of public shareholders that should have voted in favor versus against. This condition was not there earlier under Indian company law, and this has been brought in by SEBI and is only applicable to listed companies. And lastly, a very interesting provision, which is even if a public shareholder is interested in the sale, even though he's a public shareholder, it's not a controlling shareholder, he would be disqualified from voting in such a resolution. I think that covers the takeover and the corporate section. Thank you.
Right. Thanks, Anand. Which brings us to the second part of this presentation, which is acquisition financing. As many of you may be aware, it is extremely usual while making M&A transaction, acquirers take a certain part of that acquisition consideration from banks and financial institutions to have a healthy debt and equity mix. This market is also referred to as the leverage finance market, and this is something that is also picking up onshore in India. And what I will be covering through the course of my presentation will be the key legal considerations and regulatory consideration which impacts the structuring of such acquisition financing transactions, especially in the listed M&A space, and also deal with the two primary forms of acquisition financing: an offshore leverage finance transaction and an onshore debt raise for acquisition. So to start out, I'll just at the very outset set the basic legal and regulatory consideration which drives structuring of these transactions. I would divide them into three broad buckets: foreign exchange control regulations, open offer triggers for listed companies, which my colleague Anand has detailed in sort of great detail. So I won't go into the thresholds, but I'll sort of deal with the issues that lenders have to handle while doing such financings. And the third being disclosures of encumbrances, which also interestingly has a very important aspect to play in structuring, especially from the acquirer's perspective. So firstly, on exchange control regulations, as you'd be aware, India is an exchange control economy. The rupee is not freely convertible. So there are a lot of regulations which govern what kind of security that can be taken over Indian assets for foreign currency financings, and what and how non-resident entities or companies or even individuals who hold Indian companies' shares, what kind of transactions they can enter into. In fact, the mode of financing, the way foreign currency comes into India is also heavily regulated, and there are conditionalities around it. So the most important condition here is really domestic assets of an Indian company cannot be secured or collateralized for an offshore foreign currency borrowing availed by the parent company or the acquirer if it is a non-resident entity. In fact, the regulations go one step ahead. If a non-resident entity which has acquired shares of an Indian company or is about to acquire shares of an Indian company, a pledge on such shares can only be created if the facility is availed by its direct shareholder or the promoter of the Indian company. And Anand dealt with who promoters are, who are effectively the dominant shareholders of the company, or the overseas group company of the target company. Additionally, the financing has to be raised from what is classified as an overseas bank, so it has to be a regulated entity. This financing, which is raised offshore, cannot actually be used for capital inflows into India and should not result in a direct or indirect investment in India. So this in turn creates a great limitation where for an offshore acquisition financing, if the proceeds are proposed to be used for acquiring shares of an Indian company or an Indian listed company, then in such a situation, those shares cannot be provided as security. So this is only relevant in situations where there is an existing holding and the acquirer is seeking to sort of collateralize or leverage such holdings for its existing business overseas. So therefore, acquirers really have to look at other ways in which security can be taken, and I'll touch upon that in my next slide. Going to open offer triggers. So as Anand mentioned, there are certain triggers which may result in a mandatory tender offer to be made to all the shareholders, including the public shareholders. This is when the stake is large, which is being acquired, and the first trigger being the 25% trigger or a change of control. Now, from a lender perspective, it is very important to analyze this, simply because lenders also have to look at it from a doomsday scenario perspective. In case there is a default in the loan that they are providing, what is the manner in which they will enforce, and what are the limitations which arise when they are enforcing such security. And in this regard, they really have to also appreciate and examine what is the impact of even an overseas security. For example, a pledge of shares of the overseas company, which is acquiring the shares in the Indian company. Enforcement of pledge at that company, if it is above 51%, and which entitles that company to control voting rights over and above the thresholds that Anand mentioned, may also trigger an indirect open offer. Therefore, it is also important not only to see what the Indian security or the direct Indian shareholding is, but also important to see what is the implications of enforcing the overseas collateral that a lender has. The third important consideration is disclosures of encumbrances. Now, Indian stock exchanges and regulators have incentivized and encouraged and nudged greater level of disclosures. Historically, promoters or dominant shareholders of listed companies have leveraged their shareholdings, which in turn, when there has been a default, there has been a sudden change of control in the company and the share prices have plummeted, which has negatively impacted the public shareholders. So therefore, there is a SEBI regulation which mandates that in case there is an encumbrance of the shareholding of an Indian company, and this would include a direct or an indirect encumbrance, which means even if there is an encumbrance at the overseas holding company level, that has to be disclosed to the stock exchange. And this may have, of course, its market implications on the share price. So therefore, acquirers and borrowers would typically not want to disclose a transaction, but it is important to note that the SEBI takeover regulation mandates that in case a pledge is taken directly or indirectly of over 5% of the shares of a listed company, that needs to be disclosed, and even a sort of increase in pledge of 2% and more will need to be disclosed. In fact, if the borrower or the holder of the listed shares, which is a promoter, then any encumbrance created by it will need to be disclosed. Now, it is important to understand what kind of encumbrances are disclosable. Of course, the regulations have evolved. Originally, the regulations only prescribed pledges to be disclosable. However, lenders, had cute structures where there were quasi-pledges created, what is traditionally known as the dirty pledge, which would mean a contractual non-disposal undertaking, along with a power of attorney, which allows the lender to sell, which has the same effect as a pledge. So the regulators have, of course, grown wise to such structures and have widely worded what encumbrances are disclosable, and any form of encumbrances, including non-disposal undertakings, would be disclosable to the exchange if it triggers the sort of disclosure triggers that I mentioned. Moving on to the first major type of financing, which is acquisition finance structures, which I mentioned. There is a very mature leverage finance market overseas, where especially financial sponsors which have incorporated SPVs outside India and they are planning to make an acquisition, they can raise money overseas from banks, financial institutions to finance that acquisition. Now, as I mentioned, there are obviously issues in taking Indian share pledges. So that is a limitation which needs to be factored in. So what overseas lenders would typically do in such a situation is that they would build in rights which in turn would entitle them, in case of a default, to take control or in some manner control the overseas holding company, which in turn would result in controlling the stake that that company holds in the Indian company and effectively be able to monetize that stake, right? So therefore, it is very important to understand that an enforcement at the overseas company level as well may trigger an open offer. But of course, that would depend on the percentage stake that is acquired by the acquirer. Now, the other one I had mentioned, I mean, there can be no hard security on the Indian assets for such financings, and there is no guarantee available from the Indian companies. Therefore, it has to be entirely offshore security. Of course, an exception to this is dividend recapitalization facilities, where there are entities which already hold, either funds or even strategic acquirers which hold an existing stake, and they want to raise financing on the back of that stake for their overseas business, or even to declare dividend or returns to its investors. Who can finance such acquisitions? Like I mentioned, if it is one of those limited facilities where there is a pledge which is available, then it has to be an overseas bank which is financing such facilities. Otherwise, of course, there are no limitations, because this is purely an offshore financing which is being raised. Of course, as I mentioned, the main driving factor for these kind of transactions then would be the resultant implications of creation of an indirect share pledge by way of pledge of the overseas company. Does it result in a disclosure? And the second being, in case of an enforcement of such share pledge, does it result in an open offer? Now, interestingly, there has been a sort of there has been an existing judgment of the Securities Appellate Tribunal, which sits in appeal over SEBI's decision, which states that a security agent or a lender which is enforcing shares or a share pledge would in fact trigger an open offer. Now, this is not exactly an ideal position for a lender, because in effect, they are really invoking the pledge to sell it to a third party, and it is only the acquirer which would really make that open offer, or should have the obligation to make that open offer. So this is a limitation which lenders have to work with, and typically the invocation of the pledge is only undertaken when there is a sort of buyer in sight who could make that open offer. This is mainly because of the technicality of the way pledge is enforced in India, meaning that the shares actually get transferred to the pledgee's depository participant account. A recent Supreme Court judgment has, of course, delineated the sort of way in which beneficial ownership is seen, and they have said, in fact, reiterated that a pledge is really a right to sell. So therefore, they have bifurcated invocation of share pledge and the actual sale pursuant to enforcement of the share pledge, which should ideally be the trigger for open offer. And I think, however, this is an area which maybe the regulator may need to legislate on, or there may need to be some sort of clarificatory judgments to sort of clear the waters on this issue. Now, like I mentioned, since there are a lot of limitations on pledges, one important way in which lenders can really protect themselves and take a non-disposal undertaking, even though it's disposable. A non-disposal undertaking is permitted for acquisition financings, where if proceeds are being used, which are raised offshore, are used for acquiring shares of an Indian company. So this is a way in which in fact the depository has a mechanism in which the shares can be put in a lockbox, and the performance risk is something that the lenders can really mitigate with this. Moving ahead to onshore acquisition financing, this is a more sort of nascent market. Who are the lenders who finance these kind of acquisitions? Domestic banks have RBI regulations which prevent it from making from financing acquisition of shares other than in the infrastructure sector. So traditionally, non-banking finance companies registered with RBI have been doing this. Now, more recently, there are a lot of private credit funds which are registered as alternative investment funds, which are registered with SEBI, and they are sort of allowed to finance or subscribe to corporate bonds, or what in India is called non-convertible debentures. And this financing is used for making acquisitions. Because sometimes when there is a domestic acquirer, or even if there is an offshore acquirer, sometimes commercially it makes sense to raise money in Indian rupees and onshore, and that is one way in which that can be done. However, one important sort of legal consideration to keep in mind here is that if it is a foreign-owned company, the foreign direct investment policy does not allow it to raise domestic leverage for making the downstream investment or the acquisition, in the company. So therefore, really they need to look at foreign portfolio investors who are overseas entities which are registered with SEBI, and they are allowed to subscribe to corporate bonds which are denominated in rupees and issued in India. So that is that's really the most common way in which acquisition financing is raised by such FOCCs. So they cannot really go to non-banking finance companies. The other legal issue that lenders typically grapple with, and especially in a listed company, which has to mandatorily under law be a public limited company, is something that is there, which has been there in the Companies Act in its previous iteration as well, which is the rule against financial assistance. And what this states is that if it is a public company, the Indian company itself, the target company, cannot provide guarantee or security or any form of financial assistance for acquisition of its own shares. So therefore, if it is a private limited company, this restriction does not apply. However, if there is a sort of listed company acquisition, of course, since it will be a public limited company, this is one major credit consideration, because typically there is the acquiring company is a special purpose vehicle or a bidco which does not really have assets, and the lender is relying on the credit of the underlying company whose shares are being acquired, and that is really where the cash flow is being generated and where the assets are. So the other challenge which comes is upstreaming of the cash from the asset company to the entity where the acquisition financing is taken, and again, I think this is the one way in which lenders kind of bridge that gap is really have some form of consolidation where there is a collapsing of the structure, and then the acquisition debt is really then sitting on the asset co, and then it can be redeemed, and that's sort of one way in which this challenge can be bridged. Of course, the rule against financial assistance is applicable. So therefore, again, unlike leverage finance transactions overseas, the leverage finance lenders cannot really rely on the asset level security or even guarantee from the asset company. Therefore, what it typically relies on is a share pledge on the acquisition on the shares which are being acquired. So effectively, this is a security on the equity interest, and that is an asset of the acquiring company. High yield bonds have also been used overseas, but there are ways and there are regulatory considerations which would drive on whether this is the apt way in which financing can be done. So an overseas bond would be classified as what is called an external commercial borrowing, which will be subject to certain limitations, like there's a cap on the interest rate which is applicable, and even the end use restrictions are there. But there are certain structures in which high yield bonds have been raised in overseas capital markets, where rupees to be infused into Indian companies. That brings me to an end on the portion on acquisition financing. So over to you, Ananya.
Thanks, Tirthankar. From a disputes perspective, I think the Supreme Court decision you had mentioned on the aspect of invocation of pledge and the consequences thereof will have some impact, on the triggering of open offers upon invocation of pledge. Because, like you rightly said, the law as it currently stands is that the invocation of a pledge results as a trigger event, whereas the Supreme Court has clarified that the invocation does not transfer ownership in and of itself. And in fact, that judgment, just to add to what you had said, that judgment had very softly suggested that SEBI may consider re-examining the takeover code to avoid the ambiguity that is going to result. But till this is done, this is an area where we might see some litigation, and I just thought I'd bring that out before actually turning to the few points that I wanted to share with everyone. As we're all aware, and as Anand has explained, there can be two distinct situations where an open offer is triggered in terms of the takeover regulations. The first, of course, is if there is an open market purchase which results in thresholds provided for under the takeover regulations being crossed. The second situation is where there is an underlying agreement entered into between a buyer and a seller of shares, which is the trigger event. The purchase of the shares is the trigger event for the thresholds being crossed. In both these situations, the applicability of the takeover regulations is a given, and the entire transaction is obviously subject to scrutiny by SEBI as the market regulator. However, in the latter situation, where there is an underlying SPA or any other agreement, there also may arise certain contractual issues, which would be inter se between the signatories to the agreement. And it is these two types of disputes that I'll briefly be dealing with during 5 or 7 minutes that I have available. Now, as Anand pointed out, once the open offer process is triggered, SEBI scrutinizes the entire process. Now, in any transaction where SEBI is of the opinion that the acquirer or any other person involved in the transaction has violated a provision of the takeover regulation, Regulation 32 gives SEBI the power to issue directions against the said person. And this is, of course, a very broad power. SEBI can act suo motu. It can act on the complaint of a shareholder or any other interested party. It can even act on a whistleblower complaint. At all times, however, before passing any sort of direction, SEBI is required to follow the principles of natural justice, which means that the person against whom the complaint is made must be heard. Any order or direction that is passed by SEBI is, however, subject to appeal before the Securities Appellate Tribunal, which is provided for under the SEBI Act. The Securities Appellate Tribunal can confirm, set aside, or modify any order which is passed by SEBI. Against SAT's order, a further statutory appeal lies to the Supreme Court as well, which is also provided for under the SEBI Act, Section 15Z. And in this context, it's also important to note that the Act also excludes the jurisdiction of civil courts specifically, which means any challenge to SEBI's order must necessarily follow the process that I have just described. You cannot go to a civil court challenging them. In our experience, the primary issues we've seen in respect of which disputes have arisen are open offer valuation. And these arise because of the different valuations proposed by the acquirer and those that may be commissioned by SEBI through a third-party valuer, which it has the power to do. The second issue which has given rise to disputes on occasion is that of disclosures. And as Anand has explained, disclosure requirements exist under the takeover regulations at various stages, with their purpose being to ensure that no false market is created for a company's securities. Oftentimes, however, there are omissions or there are alleged omissions to make disclosures on the basis that the information in question was not material. And these have been the subject matters of dispute. Recent SAT decisions on this point, however, tend to lead to the conclusion that the requirement of disclosure, even if the company doubts its materiality, there is a requirement of disclosure. A third issue which had given rise to many disputes in the past was that relating to the concept of persons acting in concert, which also Anand had touched upon. Recently, however, particularly after the amendment to the takeover regulations, this has become less of an issue since the market practices have stabilized on. What we see is that on the regulatory side, there are certain issues which I would classify as in rem issues. These affect all stakeholders in the acquisition process. And insofar as these issues are concerned, it is SEBI and SAT, and obviously the Supreme Court thereafter, which exercise jurisdiction. If we move on, however, to the second category of disputes that can arise, and I would classify these as in personam disputes. These would be the disputes that arise out of or in relation to the SPA or to the underlying agreement. Disputes in these cases can relate to incorrect representations and warranties. They could relate to material adverse changes that take place in respect of the target company after the execution of the agreement. They could relate to fraud. They could relate to valuation. They could relate to post-closing price adjustment mechanisms. There are various disputes, and these are the primary ones. Now, in the contractual scenario, the parties to the contract would have recourse to dispute resolution fora, private dispute resolution fora in that sense, and where they may seek injunctions, they may seek damages, they may seek indemnification, they may seek specific performance of the agreement. Each remedy, of course, being subject to discharge of the applicable legal standard for its availability. In M&A transactions, the preferred form of dispute resolution that we have seen is often arbitration. Moreover, with the recent judgments of the Supreme Court upholding interim awards given by foreign seated tribunals, permitting two Indian parties to have a foreign seat, the popularity of this mechanism is increasing among multinational corporations and majority-owned subsidiaries of foreign companies. In most situations, our experience shows that parties prefer institutional arbitration in such cases as opposed to ad hoc arbitration, which is otherwise more common in India. If there is, however, no arbitration clause in an agreement, then the forum for dispute resolution would be the commercial courts, which have been set up under the Commercial Courts Act of 2015. Both with respect to arbitration as well as before commercial courts, respective statutes now provide for time-bound disposal of disputes. Experience again, however, shows that timelines are more capable of being met in arbitration rather than before the commercial courts, which is probably why arbitration is still a preferred mechanism. In India, recently, there has also been a greater push for mediation as a dispute resolution mechanism. I'm not sure, however, in cases relating to M&A, whether it's going to be a viable option. And this is something that remains to be seen. The last point that I'd like to make before I close is the potential interplay between these in rem proceedings and the in personam proceedings that I've described. Now, as I'd mentioned, there may be certain situations where on account of misrepresentation or a MAC event happening or on account of fraud, the non-breaching party can actually avoid the transaction. They can rescind the agreement that they have entered into. And as you would also recall, it was this transaction, this underlying agreement that resulted in the open offer being triggered. The question that arises, therefore, is whether voiding of the underlying agreement gives the acquirer the option to avoid the open offer as well. In this regard, the pre-amendment takeover regulations, as interpreted by the Supreme Court sometime in the past, prohibited the withdrawal of the open offer, notwithstanding the fact that there was a MAC event or a fraud. However, post-amendment of the takeover regulations under Regulation 23, one of these circumstances where an open offer may be withdrawn is when a condition stipulated in the agreement for acquisition attracting the obligation to make the open offer is not met for reasons outside the reasonable control of the acquirer, and consequently if the agreement is rescinded. Of course, there are certain conditions attached to this, but now it is theoretically a possibility for an open offer to be withdrawn if the underlying agreement is rescinded. The law, as it stands today, permits this. Now, while this is yet to be tested before the Supreme Court, the benefit of the amended provision on a plain reading would fit with the rationale that when there is no change in control on account of the underlying agreement being rescinded, minority shareholder interests remain unaffected, and consequently the withdrawal of the open offer is not prejudicial. With that, I'll conclude my part of today's session. I think we're also coming to an end of our time. In case Anand and Tirthankar, if there's anything you'd like to add please do so. I don't think there are any questions that are there for us to answer, but if you have any closing thoughts.
I think if anybody has any questions, maybe you can just type them out in the question box and we can give a minute for that. I know that was a lot of information for a 1 hour slot, but do feel free to ask any questions. If there is any questions which come to any of you later, please do write to us and we'd be happy to answer those questions. Or maybe if you have Sandra's email ID, maybe you can write to Sandra, whoever you're contacting in Lexology. I think in terms of closing comments, Anand, if you have anything, maybe you can start out and I'll add and then we can close this presentation.
So, I look forward to the questions. And as I mentioned, there's a lot to consume in an hour slot. So please reflect upon this, and if any questions come up, we'll be happy to answer.
And then thank you, everyone, and good night. Thank you for being here with us. Thanks, Tirthankar. Thanks, Anand.
Thank you.
Thanks, everyone.